Representative Guffey, thank you for coming back. I'm sorry for the circumstances which bring you, but it shows real courage, and I know your family and friends have joined you
Thank you.
in coming here today. I recall the first time we met after a hearing a year or so ago before this committee. So thank you very much.
Thank you.
Mr. Chairman, was it a week or 2 weeks ago we had a hearing on fentanyl? Yeah. And
last week.
And we had another parent of a victim who ordered what he thought was a Percocet, turned out to be laced with fentanyl, and took his life. So this is a life or death proposition that we're dealing with here, and you've lived it and living it still. I think we ought to keep it in that context. Professor Leary, I'm struck by one of your statements that you've given to the committee, that this notion that we are preparing 230 as an immunity as opposed to a defense precludes evidence being gathered and discovery taking place. And you say in your remarks to the committee that that diminishes our knowledge of the actual goings on at these tech companies and what they're doing in gathering. I recall what Representative Guffey said in his opening remarks. This is bigger than big tobacco. I know that issue. Over 30 years ago in the House, I introduced a little bill to ban smoking on airplanes. It passed because Congress is the biggest frequent flyer club in the world, and we were sick of it. And it triggered a conversation and a discovery process, and AGs from across the country gathered together and did something significant with this industry. So I'd like you to expound a bit, if you will, as to how this standard precludes our knowledge of what's actually going on in big tech in their response to this challenge. I think that the gathering of that information for the tobacco companies, the demonstration of their lying to the public about the safety of their product, for example, really led to their downfall. I think the same could be true here.
Thank you, Senator. I think that you are 100% correct on that. When a defendant has a defense, as I know the committee knows, but to be responsive to the question, there's a period of discovery beforehand.
Like contributory negligence.
Exactly, or things of that nature. There's a period of discovery where the plaintiffs can, who've made a good faith claim, can get information to build on their case, and the defendants can also provide information which may exculpate them. The way that Section 230 has been interpreted, it is an immunity. And so prior to discovery is when these platforms are coming into court and saying, Judge, we don't have to defend ourselves. We don't even have to litigate this case. You should dismiss it now. Motions to dismiss prior to discovery. The only way that I would say the public has learned a lot of the information about big tech, for example, that I believe led to COSA and some of the other duty of care, has been through what? Congressional investigations. I'm reminded of the back page of congressional investigation, which was a 2-year investigation, or whistleblowers and hearings. That's how we are learning this information, and only by getting this information can we then make informed choices about what's the appropriate legislative text. If I could just say quickly, Justice Thomas commented on this, and he has underscored this when he said, look, let's keep in mind, if we fix Section 230, that's not exactly what he said, but after that he said, quote, it would simply give plaintiffs a chance to raise their claims in the first place. Plaintiffs must still prove the merits of their case, and some claims will undoubtedly fail. But states and the federal government will be able to update their liability laws to be more appropriate for an internet-driven society.
If I can make one final point in the closing seconds here. Going back to my analogy, smoking on airplanes and ultimately dealing with the tobacco issue in a much larger context, the initial bill that I introduced and passed in the House banned smoking on airplanes on flights of 2 hours or less. People said, what are you talking about? If it's dangerous regardless of the duration of the flight. The reason was I had a Minnesota congressman who was a chain smoker who was holding up my bill, and I went to him. He's passed.
So timely that
I went to him and I said, Marty, how long can you go without a cigarette? And he said 2 hours. So I put that in the bill, and he didn't object to it, and it moved forward. There are things that we're dealing with in some of these bills which are compromises to try to move the issue forward to make progress toward our goal. So don't assume that any language is final. It is all in flux and subject to negotiation. But thank you for joining us.